courtroom was packed that morning. Every seat filled. People standing along the back wall. A crowd that had woken up early, driven across town, and pressed themselves into wooden benches just to witness what was about to happen to Dr. Serena Miles. Most of them expected to watch her lose. Judge Clifford Hargrove looked down from the bench with the expression of a man who had already decided the outcome before the bailiff called the room to order. He adjusted his glasses slowly, deliberately, the way powerful men do when they want you to feel how much time they own. Then he looked at Serena. She was standing at the defendant's table in a navy blazer, natural hair, hands resting calmly on a leather folder. No panic, no apology written on her face. Hargrove leaned back in his chair, exhaled through his nose and picked up her file, then set it back down without reading it. A deliberate insult. The kind that said, "You are not worth my preparation." He turned to his clerk and said loudly enough for the entire room to hear, "Another one from the community outreach crowd." A small smirk. "Let's keep this moving." Then he looked directly at Serena, at her dark skin, her natural hair, her calm posture, and something flickered in his eyes. Not anger, something colder than anger. Dismissal. "I've seen your type before, Miss Miles. Community agitators who think a little classroom education makes them experts on the law." He paused, letting the words land. "People like you come into this courtroom convinced the rules don't apply to them. That conviction," he tapped the file with one finger, "tends to be expensive." Then, as if she were already gone, he looked down at his papers and waved one hand sideways, the kind of gesture you make at a fly. "This is my courtroom, not your lecture hall." The room held its breath. What Judge Hargrove did not know, what no one in that room knew except Serena herself, was that the woman standing quietly before him had once argued a case before the Federal Circuit Court of Appeals, and won. If you want to know what happened next, stay with us. This story is going to take you somewhere real. Drop a comment telling us where you're watching from and what time it is right now. And if stories like this one matter to you, hit subscribe. We tell these every week and you won't want to miss what's coming. The morning light came through the tall windows of room 114 at Crestwood Community College in long, flat strips that fell across the desks like chalk lines on a courtroom floor. Dr. Serena Miles stood at the whiteboard with a blue marker in her hand, and 32 students watched her the way students only watch a teacher they actually trust. "Brown versus Board of Education," she said, underlining the words she had just written. "Most of you know the name. Some of you can tell me the year. But how many of you can tell me why it's unfinished? Silence." Then a young woman in the second row raised her hand slowly. "Because the schools are still segregated, just differently now." Serena pointed at her. "Write that down. That's the whole semester in one sentence." She set the marker down and leaned against the edge of her desk, the posture of someone completely at ease in a room, someone who had stood in far harder places than this, and learned that stillness is its own kind of authority. Serena Miles was 45 years old. She had taught political science and constitutional studies at Crestwood for 11 years. Her students called her Dr. Miles in class and texted each other about her outside of it, not because she was easy, but because she was honest. She told them what the law actually was not what the textbooks wanted them to believe it was. What her students did not know, what almost no one in Millhaven, Georgia knew, was that before Serena Miles became a community college instructor, she had graduated from Yale Law School. Class of 1999. Second in her graduating cohort. She had spent 8 years after that as a federal public defender in Atlanta, standing in courtrooms not unlike Hargrove's, fighting for people who could not fight for themselves. She had left the law in 2007, not because she lost faith in justice, because she watched an innocent man named Marcus Jeffries go to prison for a crime she knew he did not commit. And the system, every procedural gear, every institutional mechanism had moved against him anyway. Marcus Jeffries died inside that prison before his case could be reopened. He was 31 years old. Serena had packed up her office the following Monday. She did not cry. She made a decision she would teach. She would build the next generation of people who understood the law well enough to protect themselves from it. She never told anyone at Crestwood about Yale, about the bar, about the 8 years. It was not a secret she protected out of shame. It was a tool she kept sharp by keeping it quiet. Outside the classroom, Serena ran a volunteer program called the Legal Literacy Initiative, a community service operating out of a church basement on Tuesdays and Thursdays, where she helped families understand how to navigate the justice system, how to read a court notice, how to file a standard appeal form, how to know your rights before a hearing. Nothing that required a law license. Everything that required someone who actually knew what they were talking about. 3 weeks before the morning in Hargrove's courtroom, Serena had appeared before the Millhaven City Council to present something she had spent 4 months assembling. Data, her own data pulled from public court records. 847 cases from Judge Clifford Hargrove's courtroom over 7 years, cross-referenced by race charge and sentence length. The findings were not ambiguous. Black defendants in Hargrove's court received sentences averaging 34% longer than white defendants convicted of identical crimes, with identical prior records. She had not gone to that meeting looking for a fight. She had gone with a spreadsheet, a printed report, and the measured voice of someone presenting a research finding. She had gone because the data existed, and because pretending it did not exist was not something she was capable of doing. What she had not known, what she only discovered when she walked into the council chamber, was that Judge Clifford Hargrove was sitting in the 3rd row. He had been invited as a community leader, a guest of honor. He was shaking hands with the council chair when Serena set up her laptop at the presentation podium. When her first slide appeared on the screen, a bar chart with his name in the title, Hargrove, went very still. She presented for 14 minutes. Clean, methodical, devastating. The room was silent by the 3rd slide. When she finished, before the council chair could respond, Hargrove stood. He began to clap, slowly, deliberately, each clap a small detonation in the quiet room. Very theatrical, Dr. Miles. He said, his voice carrying the practiced authority of a man who had spent 15 years being the loudest person in every room he entered. Unfortunately, statistics without context are just propaganda. So every head in the chamber turned to Serena. She did not step back from the podium. She did not look down. Your Honor, I'd be happy to provide full case files as context, she said. All 847 of them. The silence that followed was different from the silence before. It had weight. It had direction. Hargrove sat back down. He did not speak again for the rest of the meeting, but as Serena gathered her papers and walked toward the exit, she felt his eyes on her back. Steady, cold, and very deliberate. Her colleague, Pat Dawson, was waiting in the hallway. Pat grabbed her arm the moment the door closed behind them, eyes wide. Serena, you just did that, in front of him, to his face. Serena looked at her. He was in the room, Pat. The data was still true. She drove home that evening thinking about nothing in particular. She graded 2 essays, made tea, and checked her messages before bed. The notification was waiting on the Georgia Department of Justice public portal. A formal criminal complaint had been filed against Dr. Serena Miles. Charge practicing law without a license. A Class B misdemeanor. The presiding judge assigned to the case, Clifford Hargrove. Serena read it twice. Then she sat down slowly in her kitchen chair, and for a long moment she said nothing at all. Judge Clifford Hargrove's chambers at the Millhaven County Courthouse occupied the entire northeast corner of the 3rd floor. The furniture was dark mahogany. The bookshelves were full. The framed certificates on the wall had been arranged not by date but by prestige, a deliberate curation. The biography of a man who understood that power must be performed as much as it must be exercised. He was alone in that room at 7:45 The following morning, sitting at his desk with his laptop open and the volume low, watching a clip someone had uploaded to the City Council's public access channel. The clip was 43 seconds long. It showed a black woman at a podium speaking calmly, pointing to a chart. Then it showed him rising from his chair, beginning to clap. He watched it 4 times. What infuriated Hargrove was not the criticism. He had been criticized before. Lawyers criticized him in motions. Journalists criticized him in editorials. He had learned long ago that criticism was simply the tax on power, and he paid it without complaint. What infuriated him was the precision. Most people who challenged him in public forums rambled. They brought emotion, not evidence. They were easy to dismiss, easy to redirect, easy to outlast. But this woman, this community college instructor, had brought 847 cases. She had brought a methodology. She had brought footnotes. She had made him look like a subject of study. He closed the laptop and picked up his phone. The call he made first was not to his clerk. It was to a man named Douglas Fitch, a city councilman who owed Hargrove 3 favorable rulings and understood exactly what that debt required of him. The conversation was short. Hargrove did not explain himself. He rarely did. The second call was to his clerk, Dennis Fowler. Dennis had worked in Hargrove's courtroom for 9 years. He was a careful man, methodical, the kind of employee who filed everything in triplicate and kept his opinions in a locked drawer. He appeared in Hargrove's doorway within 4 minutes, holding a notepad. The complaint against Miles, Hargrove said, without looking up from the papers on his desk. I want it processed today. Skip the state bar preliminary screening, Atsu. Dennis's pen hovered above the notepad. Sir, the screening protocol is mandatory for complaints of this. Your job is paperwork, Dennis, not conscience. The room was quiet for a moment. Dennis wrote something on the notepad, though neither of them could have said what. The complainant, Hargrove continued, is Raymond Boggs. He'll be cooperative. I've made sure of that. Dennis Fowler nodded slowly and left the room. What Dennis did not say, what he had never said in 9 years behind that desk, was that he had seen this before. Not once. Not twice. He had seen the shape of it 5 times in 7 years, always the same pattern. A name crossed Hargrove's desk, a complaint followed within days, a person who had stood up in public, sat down very quickly afterward. Dennis had processed each one. He had told himself it was not his place to ask questions. He told himself that again now, walking back down the hall. Hargrove returned to his laptop. His phone rang. He looked at the screen. His daughter. Lauren Hargrove was 24 years old and in her 3rd year at Emory Law School. She called on Sunday evenings, usually brief and dutiful conversations about nothing important. She was not supposed to be calling on a Tuesday morning. He answered, Dad. Her voice was different from her Sunday voice, more direct, more careful. I saw the video from the council meeting, the one with the professor. She's not a professor. She teaches at a community college. She had 800 cases, Dad, sorted by race and sentence length. A pause. Is any of it true? Hargrove leaned back in his chair. She's an activist cherry-picking data to make a name for herself. I'm in law school, Lauren said quietly. I know what cherry-picking looks like. This didn't look like that. He said nothing for 3 seconds. Then, I have a hearing at 9. He ended the call. He sat with the phone face down on his desk and looked at the wall of certificates and the framed photograph of himself shaking hands with the governor and the shelf of leather-bound statutes he had never once needed to open because he had stopped believing the law applied to him the same way it applied to other people. His daughter's voice stayed in the room longer than he wanted it to. He pushed it aside. He had a mechanism in motion now. The complaint would be filed, processed, and on Serena Miles's doorstep within 24 hours. She would receive it the way everyone else received these things, with fear, with confusion, with the overwhelming desire to make it go away quietly. That evening, Hargrove attended a dinner hosted by the Millhaven Business Coalition. Between the appetizers and the main course, he leaned toward the man to his right, a member of the Crestwood College Board of Trustees, and spoke in the measured, regretful tone of a civic leader reluctantly raising a concern. "Well, I've been hearing things about one of your faculty members," he said, swirling his water glass. "A Dr. Miles. Apparently she's been providing legal services without proper credentials, mixing politics with her classroom. You know how these situations can escalate." The board member set down his fork. "I'll look into it," he said. Hargrove nodded slowly. "I'm sure it's nothing serious, but students deserve better than an instructor with legal problems, don't you think?" The trap had two jaws now, one in the courthouse, one in the college. By the time Serena Miles opened that notification on her laptop that night, both jaws were already closing. Dean Eleanor Shaw's office smelled like coffee and anxiety. She was standing when Serena arrived, not a good sign. People who deliver difficult news while standing are people who want the option to step backward. "Close the door, Serena." Serena closed it and sat down in the chair across from the desk without being asked. She had learned long ago that sitting before you are offered a seat in a difficult conversation is a small but important act of sovereignty. Eleanor Shaw was not a bad person. Serena had always believed that. She was a careful administrator who had spent 22 years learning how to protect her institution by sensing which direction the wind was blowing before anyone else did. Today, the wind was coming from somewhere cold. She slid a printed document across the desk. "The board contacted me this morning. One of the trustees received a call last night from a community leader they didn't say who expressing concerns about your, quote, extracurricular legal activities." She folded her hands. "And then there's this." Serena picked up the document. It was a copy of the criminal complaint. Class B misdemeanor. Practicing law without a license. Presiding judge. Clifford Hargrove. She read it carefully, the way she had been trained to read documents, not for the emotional impact, but for the specific language, the procedural details, the things that were present, and the things that were conspicuously absent. "The board is watching," Eleanor continued. "They're already discussing whether to accelerate your contract review. I want to be honest with you, Serena, because I think you deserve that. This situation, if it escalates, could affect your position here." Serena set the document down and looked at the dean evenly. "I helped a man named Raymond Boggs fill out a standard appeal form, a form that is publicly available on the Georgia Court website. That is the totality of what I did." "I believe you. Then you know this complaint has no legal foundation." Eleanor looked at her hands. "What I know and what the board responds to are sometimes different things." Serena left the office 10 minutes later with the document folded in her jacket pocket and a very clear understanding of how far Hargrove's reach extended. He had not just filed a charge. He had made a phone call to someone who made a phone call. That was how these things worked. Not with force, with friction. She sat in her car in the parking lot and called Raymond Boggs. The phone rang 4 times. He picked up with the careful silence of a man who had been waiting for this call and dreading it in equal measure. "Mr. Boggs, it's Dr. Miles. I need to ask you something directly, and I need you to be honest with me." In the background, she could hear a television. A news anchor's voice, bright and ceremonial. "Presented with the Millhaven Judicial Excellence Award this morning. Judge Clifford Hargrove accepted the honor before a crowd of community leaders and local officials. Mr. Boggs, I know why you're calling." His voice was low, compressed, a voice that had been living under pressure for days. "I didn't want to do it. I want you to know that." Who asked you to file the complaint? A long pause. The television in the background cut to applause. A man came to see me, Boggs said slowly. From the city. He said there were questions about whether you were licensed to help me the way you did. He said if I just signed the form it would be a routine review, nothing serious, it would all go away. And if you didn't sign, silence, a different kind of silence. Mr. Boggs, his voice dropped to almost nothing. They told me if I didn't sign, my son's parole hearing would be... He stopped. The sentence hung in the air, unfinished and complete at the same time. I can't. I'm sorry. I can't say any more. I have to go. The call ended. Serena sat in her car and did not move for almost a full minute. She had understood from the moment she saw Hargrove's name on that complaint that this was retaliation. She had understood it was fabricated. She had understood it was a mechanism designed to frighten and silence her, the same mechanism he had used on others before her. But this was something different. Hargrove had not just pressured Raymond Boggs to sign a document. He had threatened a man's incarcerated son. He had used the fate of a person behind bars, a person who had no voice, no recourse, no way to protect himself, as leverage to get a signature on a piece of paper. Serena opened her notebook. She wrote down every word Raymond Boggs had said in order with a timestamp. Then she pulled out her laptop and began to search. 3 organizations in Millhaven similar to hers had faced comparable complaints in the past 5 years. 2 had closed. 1 had issued a public apology and stopped offering legal literacy services entirely. All 3 incidents occurred within 60 days of a public disagreement with Hargrove's court. Pat Dawson called at 7:15 that evening. Serena, I heard someone's been calling around asking about your academic history. Whether you have any legal credentials. Who told you that? Someone in administration. They seemed nervous. After she hung up, Serena sat on the floor of her living room, not dramatically, just practically the way you sit when you need to spread papers around you. She opened a dusty box she had carried from apartment to apartment for 18 years without ever fully unpacking. Case files, legal notepads, a photograph of herself at 27, standing outside the Atlanta Public Defender's office on her first day. She found the folder near the bottom. The name on the tab, written in her own handwriting, Marcus Jeffries, 2005 to 2007. She held it without opening it. This is why you left, she thought. And this is why you stayed ready. She set the folder down gently and picked up her pen. The Millhaven County Public Records Office opened at 8:30 in the morning and smelled like old carpet and recycled air. Serena arrived at 8:29 with a printed list of requests she had written out by hand the night before, because handwritten lists made courthouse clerks nervous in productive ways. The clerk at the front window was a man in his 50s named Gerald, according to his badge with reading glasses pushed up on his forehead and the expression of someone who had stopped being surprised by anything years ago. He took Serena's list and read it without speaking. Then he read it again. These are very specific requests, he said. I'm a very specific person, Serena said. She had requested 3 categories of documents. First, every complaint filed against community legal advocates and volunteer organizations in Millhaven County over the past 7 years. Second, full sentencing data from Hargrove's court, sortable by charge type and defendant race. Third, all contempt of court citations issued from Hargrove's courtroom over the same period, with corresponding case numbers. Gerald took 40 minutes to pull the files. Serena sat in a plastic chair and used the time to review the Georgia Code section she intended to cite on Friday. She did not need to review it. She had it memorized. But reviewing it helped her think. When the stack of folders landed on the counter in front of her, Gerald looked at her over his reading glasses. See, most folks representing themselves don't know to ask for half of this. Most folks representing themselves aren't me, she said. She worked through the records for 3 hours at a reading table near the window. What she found confirmed the pattern she had already suspected and extended it in ways that turned her stomach. Hargrove's contempt citations had increased by 400% since he took the bench. The increase tracked almost perfectly with the growth of civic organizations in Millhaven's black community. Every complainant in those files had within 30 days, prior, done something publicly visible, testified at a city meeting, published a letter, organized a neighborhood petition. None of them had fought back. At noon, her phone buzzed. A text from an unknown number: check the filing timestamp on the Boggs complaint. Then check the courthouse entry log for 7:48 a.m. on October 14th. A friend. Serena read it twice and set the phone face down on the table. She already knew who the friend was. Calvin Reed called at 1:15. He was 29 years old and worked the local accountability beat for the Millhaven Courier. He had been investigating Hargrove independently for 6 months, he said, and had seen the city council video 4 hours after it was uploaded. I have campaign finance records, he told her. 3 developers. Every time someone challenged a rezoning decision in Hargrove's court, they lost. Every single time for 8 years. And those 3 developers donated to his re-election campaign within 60 days of every ruling. How solid is it? Solid enough for a story. Not solid enough to survive his lawyers. A pause. But combined with what you have, not yet, Serena said. Friday 1st, then we talk. She made 3 calls before leaving the records office. The first was to a classmate from Yale, now a senior attorney in the DOJ's Civil Rights Division in Washington. She did not explain everything. She explained enough. Be available Friday morning. I may need to say your name out loud in a courtroom. Her classmate said, I'll clear my calendar. The second call was to the State Bar of Georgia's ethics hotline. She asked a single question: whether assisting a citizen in completing and filing a publicly available court appeal form constituted the practice of law under Georgia Code 15-1950. The answer took 9 minutes to receive and was unambiguous. It did not. The third call was to the courthouse clerk's scheduling office. She notified them that she would be representing herself at Friday's hearing. The woman on the phone paused before saying, That's noted Dr. Miles. That evening, Serena pulled up the courthouse entry log through the public portal. The security system logged all keycard entries. On October 14th at 7:48 a.m., 42 minutes before the building officially opened for business, Dennis Fowler's employee ID had been scanned at the third-floor staff entrance. The Boggs complaint had been filed at 9:03 a.m. that same morning. She opened a new document and began to build a timeline. October 9th, City Council meeting Hargrove, present confrontation at the podium. October 13th, Raymond Boggs visited by a city official. October 14th, 7:48 a.m., Dennis Fowler enters courthouse before opening hours. 9:03 a.m., Boggs complaint filed bypassing State Bar screening. October 16th, Serena receives criminal summons. Each entry sat in its column like a piece of evidence that did not need anyone to explain it. The timeline explained itself. She printed it, labeled it Exhibit A, and placed it in a manila folder. Then she called Calvin Reed back. The 5 other organizations, the ones Hargrove went after before me. Can you get me contact information for anyone willing to talk? 2 said they'd speak off the record, Calvin said. 1 might go on record. She's been waiting for someone to ask. Tell her I'm asking, Serena said. She turned off the light at 11:30 and sat in the dark for a moment before bed. She thought about Raymond Boggs's voice on the phone. The sentence he had not finished. My son's parole hearing would be, she thought about what it cost a man to make that call. To say I'm sorry I can't to the person he had wronged. She picked up her pen and added his name to the top of the timeline. Not as evidence, as a reminder. The morning of Thursday began in room 114, again the way most of Serena's important days had begun, in front of students who didn't yet know they were watching something significant. She wrote Shelby County versus Holder 2013 on the whiteboard and turned to face the class. In 2013, she said, "The Supreme Court gutted the Voting Rights Act. They said the formula used to determine which states needed federal oversight was outdated. That discrimination was no longer the problem it once was." She paused. "Does anyone want to argue with that?" 6 hands went up. She let them argue for 12 minutes. She did not correct them. She redirected, questioned, pushed back. This was what she did not pour information into people but create conditions where they discovered it themselves. Dean Eleanor Shaw sat in the back row with a notepad and a pen. Per board instructions, she was conducting a formal classroom observation. She had told Serena about it the previous afternoon with an expression that communicated both obligation and apology in equal measure. Serena had taught as if she weren't there, because the students deserved that. After class, as students gathered their things and the room filled with movement and noise, a young man lingered near the door. He was 19, maybe 20, with his father's careful eyes and his father's way of standing like he was still deciding whether to take up space. Darius Fowler. He waited until the last student had left. Then he crossed the room and placed a sealed envelope on Serena's desk without speaking for a long moment. "My dad works at the courthouse," he finally said. "He asked me to give you this. He said to tell you he's sorry, that he should have done it sooner." Serena looked at the envelope, then at the young man. "Is he all right?" Darius nodded slowly in the way people nod when the honest answer is more complicated than yes or no. "He's scared," he said. "But he wants to do the right thing." "Tell him," Serena said carefully, "that what he's doing takes more courage than most people ever find." After Darius left, Serena opened the envelope. Inside was a printout of the courthouse security entry log for October 14th. Dennis Fowler's keycard entry at 7:48 a.m., highlighted in yellow. Beneath it was a second document, an internal processing record showing that the Boggs complaint had been routed directly from intake to filing without passing through the State Bar preliminary review queue. In the override field, where a justification was required, someone had typed 3 words, "Judge's direct instruction," 3 words that transformed a pattern of suspicion into a documented fact. Serena set the papers down on her desk and stood very still. She thought, as she sometimes did in moments like this, of a courtroom in Atlanta in 2007. Of a young man in an orange jumpsuit who had looked at her with the specific hope of someone who had nothing left to hope with. Of the verdict that came back wrong. Of the long drive home in silence. She thought about what it would have meant in that courtroom if someone on the inside had handed her a document like this one. She folded both papers carefully and placed them into the manila folder now relabeled Exhibit B. She would not waste what Dennis Fowler had risked to give her. That evening, Serena spread everything across her dining room table. 3 piles, 3 arguments. The first pile was the simplest. The charge itself had no legal foundation. Georgia Code 15-1950 was explicit. State Bar Ethics Opinion 2019-3 confirmed it. Raymond Boggs's own account further undermined the complaint's credibility. This argument alone should have been enough. It would not be enough. Not in Hargrove's courtroom. The second pile addressed procedural violations. The Boggs complaint had bypassed mandatory state bar screening. Dennis Fowler's entry log placed him in the building before opening hours. The internal override notation confirmed direct judicial instruction. This was not a clerical error. This was a mechanism. The third pile was the largest. 5 organizations. 7 years. A consistent pattern of complaints against Hargrove's public critics, always within 30 days of a visible disagreement, always resulting in silence or capitulation. 2 of Calvin Reed's sources had provided written statements. One had already emailed hers, 3 pages long with dates and case numbers. Serena organized each pile into labeled folders, clipped them together, and placed them in her grandfather's leather briefcase, the one she had carried through 8 years in federal courtrooms, and then packed away like something no longer needed. She picked out her outfit last. A navy blazer over a white blouse, black slacks, simple jewelry. Her natural hair the way she always wore it, full and uncompromising. She was not going to perform confidence. She was simply going to be herself, which in that courtroom would be the most disorienting thing she could possibly be. At 11 o'clock, she prepared the final document. A formal complaint addressed to the Judicial Qualifications Commission of Georgia, citing 7 years of racially disparate sentencing, systematic retaliation, and documented judicial misconduct. Signed, dated. 1 click from submission. She saved it without sending it and closed the laptop. Then she reached for the Yale casebook on the edge of the shelf, the one she had carried since the first week of law school, and never thrown away, though she could not always have explained why. On the inside cover, in the faded blue ink of a woman who had been gone for 11 years, her grandmother had written 4 lines. "They will underestimate you, baby. Every single time. Use every inch of it. Love, Grandma Ruth." Serena read it once. Then she turned off the light. The Millhaven County Courthouse opened its doors at 8 o'clock on Friday morning, and Serena Miles was already sitting in the second row of courtroom 7 by 8:15. She had chosen the second row deliberately. Close enough to observe everything clearly, far enough that Hargrove would not notice her until she needed to be noticed. She had 40 minutes before her case was called, and she intended to use them the way she had always used courtroom waiting time, reading the room, reading the judge, reading the patterns that no formal procedure ever documented. Hargrove entered at 8:22. He moved with the unhurried authority of someone for whom lateness was a prerogative rather than a failing. He settled into his chair, accepted his morning coffee from a clerk, and began reviewing files with the air of a man performing thoroughness rather than actually practicing it. The first case involved a young black man named Terrence, 23 years old, charged with misdemeanor trespassing. His public defender spoke for 3 minutes. Hargrove interrupted twice, once to question the relevance of a procedural point, once simply to glance at the clock. The sentence, 90 days, suspended with probation conditions so restrictive they were designed to be violated. The second case, a white man in his 40s, charged with aggravated trespassing on commercial property, a step up in severity. His private attorney spoke for 6 minutes and cited 2 precedents. Hargrove nodded, asked 2 clarifying questions with something almost resembling patience, and issued a fine. No jail time, no conditions. A fine. Serena noted both cases in a small notepad she kept in her jacket pocket. She was not here to be outraged. She was here to be precise. Outrage was a feeling. Precision was a weapon. She noticed Dennis Fowler at the clerk's station. He moved efficiently, professionally, the way he always did, but his eyes did not follow defendants after Hargrove issued sentences. They went immediately back to his desk. It was the practiced reflex of a man who had learned over many years not to witness what he was processing. At 9:17, Dennis called her case. Docket 118-C, State versus Miles Serena. Charge practicing law without a license. Serena stood, gathered her briefcase, and walked to the defendant's table. The room was more crowded than was typical for a Friday morning. Word had gotten around. A dozen people from her legal literacy initiative sat together in the middle rows. Calvin Reed sat in the very last row with a notepad and a pen, working hard at being invisible. Hargrove looked up from the file. He looked at her dark skin, at her natural hair, at the leather briefcase she set down without hurry, with the expression of a man checking a box. Then he looked back down at his papers. Dr. Miles, you are charged with practicing law without a license in connection with legal services you provided to one Raymond Boggs. How do you plead not guilty, Your Honor? Shut them. Securities, the record indicates you prepared and filed a legal document on Mr. Boggs's behalf without holding a current Georgia bar license. This appears to be a straightforward matter. With respect, Your Honor, the record indicates I assisted Mr. Boggs in completing a standard appeal form, Form GA7, publicly available on the Georgia Court System's official website. Under Georgia Code Section 15-1950, assisting a citizen in understanding and completing a public court document does not constitute the practice of law. Hargrove's expression did not change. The determination of what constitutes legal practice rests with this court, Miss Miles, not with a community college instructor's reading of the statute. State Bar Ethics Opinion 2019-3 specifically addresses this scenario and confirms that the activity in question does not meet the statutory definition of legal practice, Your Honor. A brief pause. Something shifted almost imperceptibly in Hargrove's posture, the slight tightening of a man who had expected this to be easier and was recalculating in real time. Miss Miles, you seem very comfortable citing legal sources for someone without a bar license. I've always believed understanding the law is every citizen's right, Your Honor. That's actually the purpose of the program. Two attorneys seated in the gallery exchanged a glance. Then Hargrove made his mistake. He had been building toward it since she walked in. She had watched it accumulate in the slight elevation of his chin, the practiced impatience, the barely concealed irritation of a man who had expected capitulation and was receiving precision instead. It came out the way these things always come out, dressed as authority, revealing itself as something else entirely. Miss Miles, I've had occasion to review your presentation to the City Council last month. Your opinions about this court's sentencing practices are noted. He let a pause fill the room. And irrelevant. The courtroom went completely still. Not the polite quiet of a room following procedure. The specific, breathless stillness of people who have just watched someone say something they cannot unsay in a place where words become part of the official record. Calvin Reed's pen stopped moving. Dennis Fowler set down his stapler. The elderly woman in the fourth row, the one who had come alone and sat with her hands folded in her lap since 8:15, closed her eyes briefly as though she had been waiting years to hear a powerful man finally say the quiet part out loud. Serena let the silence sit for exactly 2 seconds, long enough for every person in that room to understand what had just happened. Then she spoke, her voice the same temperature it had been since she walked in. I wasn't aware, Your Honor, that constitutionally protected speech at a public city council meeting was relevant to a misdemeanor charge arising from a community literacy program. Hargrove's jaw tightened visibly. Your attitude in this courtroom is entirely consistent with the attitude that generated this complaint in the first place. She reached into her briefcase. Your Honor, I'd like to enter into evidence the filing timestamp on the Boggs complaint and the courthouse security entry log for the morning of October 14th. She placed both documents on the clerk's table with the quiet certainty of someone who had been carrying them for days and finally had permission to set them down. Dennis Fowler looked at the papers. He recognized them immediately. His face did not change, but his hands resting on the desk in front of him went absolutely still. Nobody in the courtroom moved. The courtroom had gone from procedural quiet to something heavier, a held breath that nobody wanted to be the first to release. Hargrove looked at the documents Serena had placed on the clerk's table with the expression of a man who has just noticed the floor beneath him is glass. He recovered quickly. Men like Hargrove always recovered quickly, 15 years on the bench had trained him to perform composure under pressure the way other men perform breathing. Mr. Fowler, admit the documents for review. Dennis Fowler picked up the papers. His movements were careful and deliberate, the movements of a man choosing in real time how to carry something that was heavier than it looked. Hargrove scanned both pages, the entry log, the timestamp. His face stayed neutral, but a muscle moved in his jaw, once controlled, quickly suppressed. Miss Miles, a clerk arriving early is not evidence of misconduct. Individually, no. Serena agreed. In combination with the internal processing record showing, the complaint was routed directly to filing without mandatory state bar preliminary screening and the override notation in the routing field reading Judge's direct instruction, it documents a pattern of deliberate procedural deviation, Your Honor. She reached into her briefcase and withdrew the second folder. I'd also like to enter a signed statement from Raymond Boggs obtained yesterday morning, in which Mr. Boggs describes being approached by a city official and told that if he did not sign the complaint, his son's upcoming parole hearing would be adversely affected. The room contracted. 3 rows back, a woman pressed her hand flat against her mouth. One of the attorneys near the side wall slowly lowered his pen. Calvin Reed had stopped pretending to be invisible. He was leaning forward with both elbows on his knees, watching the way people watch something they know they will describe for the rest of their lives. Hargrove's voice, when it came, was measured with visible effort. That is a very serious and entirely unsubstantiated allegation. So Mr. Boggs has signed and dated the statement, Your Honor. He is prepared to testify. She placed the folder on the clerk's table. I have also documented 5 additional cases from the past 7 years in which individuals who publicly disagreed with this court subsequently faced complaints or procedural penalties within 30 days. 2 of those individuals have provided written statements. Their names and case numbers are attached. She turned slightly so that her voice carried across the entire room. In each of those 5 cases, the individual was a black resident of Millhaven who had challenged a decision affecting their community. In each case, the complaint bypassed mandatory review. In each case, the individual chose to pay a fine or issue an apology, rather than fight, not because they were wrong, but because fighting a system where the judge controls the process is not a viable option for most people. She paused. It was not a viable option for them. I am in a different position. Miss Miles, I would caution you very carefully. I'm moving for your recusal, Your Honor, under Georgia Code of Judicial Conduct, Rule 2.11. The words landed in the silence like something solid dropping onto stone. On 3 grounds, Serena continued, opening her 3rd folder. First, you have now twice in this proceeding explicitly referenced my city council presentation in a context connecting protected political speech to this criminal charge, creating an appearance of retaliatory bias that no reasonable observer could dismiss. Second, the processing record documents direct judicial instruction to bypass mandatory state bar screening with no administrative justification. Third, the pattern of 5 prior cases establishes a course of conduct that a reasonable person would conclude reflects systematic bias against critics of this court, specifically critics who are black. She straightened the folders on the table. And before Your Honor responds, I should clarify something for the record. Her voice did not rise. It did not need to. Before I became a community college instructor, I graduated from Yale Law School. I spent 8 years as a federal public defender in Atlanta. I have argued before the 11th Circuit Court of Appeals. The room couldn't breathe. Hargrove went pale. Not the flush of anger, the specific pallor of a man who has just recalculated every assumption he made this morning and found that all of them were wrong. His lips parted slightly. No words came. Dennis Fowler sat completely motionless at the clerk's station. His hands were flat on the desk. He was staring at a fixed point somewhere in the middle distance, and he was not moving and he was not pretending to work. And the expression on his face was the expression of a man who has been waiting a long time for a door to open and has just watched it open. The elderly woman in the fourth row, the one who had arrived alone and sat with folded hands since 8:15, made a sound that was not quite a laugh and not quite a cry. The woman beside her reached over and gripped her hand without looking at her. Serena placed the sealed envelope on the clerk's table beside the other folders. This envelope contains a completed formal complaint addressed to the Judicial Qualifications Commission of Georgia. It documents the sentencing disparity data from my city council presentation, the procedural violations in this case, and the 5 prior cases, and the conduct I have described this morning. I have not submitted it. I am prepared to submit it from this room today. If this court declines to recuse, she placed her hands flat on the table and looked directly at Hargrove. I know exactly what this charge is, Your Honor. The people in this room know what it is. The record now reflects what it is. A pause not for effect, but because some things deserve a moment of space before what comes next. I am asking this court to correct it. Hargrove stared at her for a long moment. Then he looked at Dennis, then at the documents on the clerk's table, then at the sealed envelope. Then he said in a voice stripped of everything except the mechanical need to produce words, "This court will take a 30-minute recess." He stood. He walked toward the side door. He did not look at Serena Miles again. The small conference room adjacent to courtroom 7 had no windows. A rectangular table, 4 chairs, a water pitcher, nobody had filled that morning. Hargrove was standing when Serena entered, jacket still on arms, crossed the body language of a man who needed the physical performance of authority because the actual authority had already left the room. Dennis Fowler had been told to wait outside. Hargrove did not offer her a seat. Serena pulled one out and sat down anyway. "What exactly do you want?" he said. No preamble, no residual courtroom gravity, just a man asking a direct question, because direct questions were the only currency he had left. Serena opened her notepad on the table. She had written her 4 conditions the night before in clear numbered lines, not as leverage, but as a record of what justice actually required. 4 things, she said. He said nothing. She continued. First, all charges dismissed with prejudice today before this court reconvenes. Not continued, not conditionally withdrawn, dismissed, with prejudice. Second, the official record notation states that dismissal was entered due to absence of legal foundation, and that the underlying complaint failed mandatory processing requirements. Third, you recuse yourself permanently from any and all matters involving me, my program, or Crestwood Community College effective today. She paused before the 4th condition, not for effect, but because she wanted to say it clearly, and she wanted him to hear it clearly. Fourth, the sentencing data from your court for the past 7 years and the 5 prior cases I documented this morning are referred to the Judicial Qualifications Commission for independent review. Hargrove uncrossed his arms. His voice was controlled, but the control was costing him something visible. The first 3 are manageable. The 4th is different. You're asking for an open-ended investigation into this court's entire record. Yes, Serena said. I am. I won't agree to that. Serena opened her laptop. She turned the screen slightly so he could see it. The completed JQC complaint, the send button, the cursor resting an inch away. What are you doing? Submitting the complaint. I prepared the filing last night. It takes approximately 40 seconds. She did not move the cursor. She simply left it where it was. I'd prefer not to submit it. I prepared it so that I could if I needed to. The room was quiet. Through the wall, the low murmur of the courtroom people waiting, talking in the hushed voices of people who knew something important was happening nearby. A knock at the door. Hargrove said nothing. The door opened anyway, Dennis Fowler stepped in. He was carrying a thin folder, and he looked like a man who had made a decision and was still in the process of surviving it. He did not look at Hargrove first. He looked at Serena. "I need to say something," Dennis said. "Mostly for the record." Dennis Hargrove started. "I processed the Boggs complaint the way I was told to process it," Dennis said. His voice was steady in the way voices are steady when someone has been rehearsing a thing for a very long time. "I've processed complaints like it before. I have documentation dates, case numbers, the override fields. I've kept copies for 3 years." He set the folder on the table, because I knew eventually someone was going to ask. He looked at Hargrove directly. "I'm sorry I waited this long." Then he looked at Serena. "And I'm sorry it took someone like her to make it possible." The silence in the room was complete. Hargrove looked at the folder on the table, at the open laptop screen, at the sealed envelope Serena had set quietly beside her notepad. The mathematics of his situation had become very simple, the kind of simple that only arrives after every other option has been removed. "Fine," he said. The word had no texture, no affect. It was the sound of something ending. All 4 conditions. When they returned to courtroom 7, the room was waiting the way rooms wait when they know something has been decided, but not yet announced. Hargrove took his seat. He adjusted his papers. He cleared his throat once. In the matter of State versus Miles, he said, "This court has reviewed the procedural record and finds that the underlying complaint was processed in a manner inconsistent with mandatory review requirements and is without sufficient legal foundation." Each word came out separately, deliberately, the way a man speaks when he is reading something he did not want to write. "Chokos, all charges are dismissed with prejudice. The court further notes a recusal in all future matters involving Dr. Miles or institutions connected to her work, effective immediately, to avoid any appearance of impropriety." He banged the gavel once. Calvin Reed was out the door before the sound finished echoing. In the 4th row, the elderly woman who had sat alone all morning pressed both hands to her face. Outside in the gray November light of the courthouse steps, she found Serena before Serena had reached the bottom stair. She was small, perhaps 70, and she moved with the careful determination of someone who had been waiting a long time to close a distance. She took Serena's hands in both of hers and held them without speaking for a moment. "My grandson," she finally said, "5 years ago, in that courtroom. He got 3 years for something the white boy beside him got probation for." She shook her head slowly. 3 years of his life. She did not say thank you. She didn't need to. Some things are communicated without language in the pressure of 2 hands holding in the specific look in an old woman's eyes. That means I have been carrying this for a very long time, and today it is slightly lighter. Serena stood on the courthouse steps and held her hands back. Then, across the street, she noticed a young woman standing apart from the small crowd that had gathered. Early 20s. Dark hair. Wearing a Emory Law School lanyard around her neck. Hands pushed into her jacket pockets, watching the courthouse steps with an expression that was equal parts resolution and grief. Lauren Hargrove. Their eyes met for a moment. Lauren gave a single small nod, the nod of someone who has done something difficult and is still deciding how to live with it. Then she turned and walked away down the sidewalk, her footsteps quiet on the wet pavement. Serena watched her go. She understood. Some reckonings belong to the person who caused them, and some of the heaviest ones are carried by the people who simply told the truth. 6 weeks after Serena Miles walked out of courtroom 7, the Millhaven Courier ran a headline across the top of its front page in the largest type Calvin Reed had ever seen his editor approve. State Commission opens formal investigation into Judge Clifford Hargrove. 47 cases under review. The story ran 4,000 words. It cited campaign finance records, 7 years of sentencing data, the 5 organizations Hargrove had systematically targeted, the override notations in the complaint processing logs, and Dennis Fowler's full testimony. By Thursday morning, it had been picked up by the Atlanta Journal-Constitution. By Friday, it had reached 2 national outlets. Hargrove was placed on administrative leave the following Monday. 4 months later, quietly without a press conference through a statement issued by his attorney, he resigned from the bench. The Judicial Qualifications Commission's report, released the following spring, cited a documented pattern of racially disparate sentencing, systematic retaliation against community critics, and improper judicial conduct in the processing of at least 11 complaints over 7 years. Of the 47 cases referred for independent review, 19 were recommended for resentencing hearings. 9 defendants, all black, all sentenced during the period under review, were determined to have received sentences materially affected by judicial bias. Terrence, the young man Serena had watched, received 90 suspended days on a trespassing charge on the morning of her own hearing. Was among them. Dennis Fowler cooperated fully with investigators. He submitted the documentation he had maintained for 3 years, a handwritten log kept in a drawer at home dates, and override records going back to the beginning. Kept because he had understood on some level that the day would come when someone would need it. He received a formal reprimand and a demotion. He kept his job. Most people who heard the outcome thought that was too lenient. Dennis Fowler thought it was more than he deserved, and he was probably right about both things. Raymond Boggs issued a public statement through a community organization attorney in December. He apologized to Serena directly in writing with his name on it without conditions. He was cooperating with investigators. His son's parole hearing was rescheduled, reviewed by a different judge, and approved 2 weeks before Christmas. Lauren Hargrove's email to Calvin Reed, sent the night of the hearing, containing a screenshot of an internal communication she had seen on her father's laptop during a visit home the previous summer, had provided the final evidentiary thread that made the JQC's case unambiguous. She had retained an attorney before sending it. She had sent it anyway. Nobody reported on Lauren's role publicly. That was her choice. Serena respected it completely. Dean Eleanor Shaw came to Serena's office on a Wednesday afternoon, 2 weeks after the story broke. She sat down without being asked, and she did not lead with pleasantries. "The board dropped the contract review," she said. "Effective immediately." She paused. "They'd also like to offer you the chairmanship of the political science department." Serena looked at her evenly. "Tell the board I appreciate the gesture. Tell them no." Shaw nodded, unsurprised. "Is there anything you would accept?" "One thing," Serena said. "Let me develop a new course, Law, Race, and Justice in America. Open enrollment, no prerequisites. Every student in this college should be able to take it." The course was approved within a week. Registration opened on a Friday afternoon. By Saturday morning, every seat was filled, and a waiting list had formed. By the following semester, it was the most enrolled course in the department's history. The Legal Literacy Initiative tripled its volunteer enrollment in 2 months. 3 neighboring counties reached out asking whether Serena could help establish similar programs. She said yes to all 3. On a Thursday in early December, Darius Fowler stayed after class. He sat in the chair beside Serena's desk, the way students do when they have something real to say and are still searching for the words. "My dad testified last week," he said. "Full testimony, on the record." He looked at the window for a moment. "He came home that night and he cried. I hadn't seen him cry since my mom passed." A pause. "He said you gave him permission to be brave." Serena thought about that. "He gave himself permission," she said. "He just needed to know the door was open." In the second week of December, a letter arrived forwarded through the college's administrative office. The return address was a small city in South Georgia. Inside was a single handwritten page. The signature at the bottom was a name she had not seen written in many years. The Jeffries family, Marcus's mother, his younger sister. We saw your name in the news, the letter began. We remembered you. We wanted you to know that we always believed you fought for him as hard as anyone could. We never blamed you. We should have said that sooner. We're glad you didn't stop. Serena read it twice. Then she folded it carefully and placed it inside the old manila folder labeled Marcus Jeffries, 2005 to 2007, and set it back on the shelf beside the Yale casebook with her grandmother's inscription. She stood in her apartment for a long moment in the quiet of a Thursday evening. On the last day of the fall semester, room 114 was more full than its capacity was supposed to allow. Students who were not enrolled had come anyway. People stood along the back wall. Serena did not comment on this. She simply began. She did not open with a case. She did not write anything on the whiteboard. She looked at them, all of them, every different face and story that had walked through that door over 4 months, and she said, "The law is not a building. It's not a bench, a gavel, or a title. It is an agreement that we make with each other about what we owe one another. And when someone breaks that agreement, when someone uses the machinery of the law to protect themselves, instead of honoring that agreement, the only thing that fixes it is a person who understands the machinery well enough to show everyone else exactly what is broken." Near the window, a young woman raised her hand. "Dr. Miles, did you ever regret leaving law?" Serena looked at her. Then she looked around the room at every face, every person, every story she would never fully know, but had spent a semester trying to teach something true. "I never left law," she said. "I just found a different kind of courtroom." Nobody applauded. It wasn't that kind of moment. It was quieter than applause and more permanent. Power will always try to convince you that the room belongs to it, that the rules serve it, that your silence is the price of your safety. But silence is not safety. It is simply a different kind of loss. What Serena Miles understood, and what Grandma Ruth wrote in the front of a casebook decades ago, is that being underestimated is not a wound. In the right hands, it is a door left unguarded. Walk through it. Know your rights. And when the room tries to tell you who you are, be absolutely certain you already know.
If this story moved you, if you've ever watched someone in power use that power to protect themselves instead of doing what was right, leave a comment below. Tell us where you're watching from. Tell us what this story made you feel. And if you believe these voices deserve to be heard, subscribe and share this with someone who needs it today. These stories exist because you show up for them.